Hi, I'm Dan Chambers, the founder of Chambers Law Firm. This is the next in a series of videos that I've put together to help you understand the criminal procedure, criminal process, and criminal court system involved in your felony or misdemeanor case. And we're getting to the very end of the felony process. In the last video, I talked to you about the possible outcomes of your trial if your felony case went to trial. Now, after that trial, there's what's called a sentencing hearing. Now, between that sentencing hearing and the jury's verdict that they rendered, there are some post-trial motions that your attorney could file on your behalf if appropriate. For example, if you believe that there was juror misconduct or if there was evidence that was newly discovered, you could move for a new trial. You could even ask the judge to set aside the jury's verdict, although it's very rare that that happens. Now, if your case goes to sentencing, you have to be sentenced by law within 20 days of the jury's rendering of the verdict in your case. Now, it's important to remember, you can always waive time. It's called waiving time, and you can say to the judge, it's okay if it takes longer than 20 days, but I want my sentencing hearing to take place later on. Perfectly fine, but by law it can happen as early as 20 days after the verdict is entered. At a felony sentencing, the judge will be provided with what's called a probation report. In felony cases, a probation report is required before your sentence unless you waive the right to a probation report. I rarely ever recommend a client not have a probation report done. It's an additional pair of eyes to allow the judge to come to what is a just sentence in your case. Now, that being said, the probation officer that's writing your report frequently skips over very important parts of your background, your education, your job, your lack of a prior record, character references, and a host of other things that can help the judge decide what is the best sentence for you. At that sentencing hearing, it's also important to remember that if you were convicted of crimes, the victim of that crime or their family may be able to speak at that hearing. California recently passed what's called Marsy's Law that increases the rights of victims to have a say in the process and outcome of cases. So you should be prepared at your sentencing hearing that you may be hearing from the victim or their family about what should happen to you. That's why it's important to make sure that you have all of the information and you're fully loaded to go to court on your sentencing hearing so that the judge can get a real sense of who you are and what's a fair result. I hope that this video has been helpful and informative to you, and more than likely you still have a lot of questions that you'd like answered. We at Chambers Law Firm pride ourselves in effectively communicating with our clients and trying to answer all of their questions about their cases. Please feel free to contact us with any questions and concerns about your specific situation. For prospective clients, we always provide a free consultation, and we have Spanish speakers available to assist you if necessary. Thank you for watching.